My lady and my lords, on behalf of the Law Society of Kenya, our duty is to set out what the law is, in view of the facts that are before the court. The law, insofar as recusal is concerned, can be well traced in Kenya in the decision of Rai Group Limited versus Kimeto and Associates. We have exhibited this decision in the list of authorities filed before the court. Permit me to set out what was reiterated in that decision. The real question is whether reasonable apprehension of bias was presented which would make an informed and fair-minded person seized of all the information surrounding this matter and the impartiality required of judges by their constitutional oath apprehend bias on the part of the bench. Now, what is the information surrounding this matter? Let us start with the case of Honorable Justice Freda Mugambi. The charge in respect of which recusal is sought is that she was an LLM student of Professor Kindiki Kithure. It has been demonstrated by facts which are not in dispute that the Honorable Judge was not an LLM student of Professor Kindiki Kithure in the Moi University or any university, but instead her LLM was obtained from the University of Birmingham. It is as simple as that. Issue number two, that Madam Florence Oluoch was appointed to a board by His Excellency President William Samuel Ruto. What are the facts? Madam Florence Oluoch was appointed to the board by Sultani Tuju. These, my lady and my lords, are the facts upon which information surrounding this matter are to be determined. The next authority which we rely upon is the case of Eli Valley Mines versus Lee. And the principle set out in that case is as follows. In this context, the reasonable person is not someone who is hypersensitive or unduly suspicious, but rather a well-informed, thoughtful observer who understands all the relevant facts and has examined the record and law. Now, insofar as Honorable Justice Freda Mugambi and Honorable Justice Eric Ogola is concerned, has there been demonstration on the basis of a reasonable person who has examined the record and law to demonstrate that there is bias, real or perceived? That is the question that this court must answer. What about Honorable Justice Anthony MRIMA? The charge is that the Speaker of the Senate, the Right Honorable Amason Kingi, attended his wedding. My lady and my lords, there must be meaning to the term learned friends. There are those who have written, including a writer by the name Jess Brailia, a book titled Lawyers and Other Reptiles. And there are those who have also written, including Feroz Norji, Practicing an Honorable Profession. Indeed, we are learned friends. A judge is first an advocate and second a judge. A judge does not reside in isolation. And if I may just say, for example, I've had a cup of tea with Justice Anthony MRIMA. I've had a cup of tea with Justice Eric Ogola. I've not been fortunate enough to have a cup of tea with Justice Freda Mugambi. Well, they are my friends. But I appear before this court and they rule in favor or against me. It is in that context that we must examine. Is the charge against Justice Anthony MRIMA one based upon information in the mind of a reasonable person who has reviewed the record of the facts and the law. And if your lordships and my lady will return a negative answer so far as these questions are concerned, then you must make a decision whether to recuse yourself or to continue handling this matter. It is my humble submission, based upon what you've said, that there is considerable doubt as to whether a case has been made out to warrant recusal. We request this court to dismiss this application. I will allow my colleague to utilize the remaining 2 of our minutes to say something.
My lords and my ladies, Nishuki for the Law Society.
I thought Havi was representing the Law Society.
Yes. My lords and my ladies, I will start off by the submission, clarification of the submission that this application for recusal is the court being called to trial. That cannot be further from the truth. An application for recusal is in its very nature a call for the court to introspect. Given that to assume otherwise would be oxymoronic, as the court would be sitting on its own trial, which is what the recusal motion is. My lord, I move on to this duty to sit. That duty is not one that should be carried lightly. That duty flows from Article 159 and the judicial authority that is vested upon you as judges. To not fulfill that duty is to abdicate a constitutional right that you've been granted. Therefore, in making this decision that you're called upon, you must always at the back of your mind have that clear obligation that has been bestowed upon you by the people of Kenya. My lord, we've heard repeatedly from the prosecuting counsels in this issue, and they've referred to perceptions. And it caused me to check what this word perception actually means. Perception flows from a Latin word, which is percipere, which means to seize or to understand. And the dictionary defines this as the way in which something is regarded, understood, or interpreted. That being said, on the facts before you, could they be perceived to put across actual or even apparent bias? That is a question you have to answer. I will discuss briefly what has been said by my colleague, my senior Mr. Somani, on the test that you must apply. That test is an objective test. That is not in question. Therefore, we call it into question the fact that reliance to show the general public perception of this bench was on a tweet by my learned senior counsel Agmenasi. We asked the court not to take that direction, as it would be then turning that test not from an objective test, but subjective test, looked at from the perceptions as they are held by senior counsel Agmenasi. Your Honor, my lords and my ladies, we ask you, please, do not fall into that folly that the applicants seek to drive you. But look, lastly, I will discuss one of our cases with regards, and this is particularly with regards to the profession, as has been discussed by seniors, that we are indeed a homogeneous group. We are all advocates. And this is particularly important when it comes to the allegations as against Justice MRIMA. In the case that we have placed before you, of Perry versus Schwarzenegger, it runs from page 62 to 82 of our bundle of authorities, which is duly filed. The court had an opportunity to discuss an issue of recusal that had been lodged as against the judge, simply on the basis that he had a similar characteristic with some of the parties. In this case, the perception of bias is that Justice MRIMA is friends with His Excellency the Senator, who is a fellow learned friend. And the court said this: in a case that could affect the general public, based on the circumstances or characteristics of various members of that public, the fact that a federal judge happens to share some of the circumstances and characteristics will only be affected in a similar manner because he is a member of the public. This is not a basis for disqualifying a judge. My Lord, having considered the law and the facts before you, it is readily apparent that this application has not risen up to call for your introspection with regards to your empanelment in this matter. That is all.
My Lord, allow me to just seek a procedural clarification that the right to reply is available only to the persons who, the advocates who filed the application, and not the parties who supported that application.
We made that clarification at the beginning.
Perhaps, my Lord, you should also confirm whether it is limited to matters of law